Good afternoon, everyone. Hello, hello, hello. I'm coming to you from Vancouver, BC, Samfiru Tumarkin's Vancouver office. My name is Darren Sall. I'm your employment lawyer today. I think I missed last 2 weeks ago session, so it's good to be back and to hopefully answer everyone's questions here today. Coming to you again from Vancouver. It's where it's taking a turn for the colder. So if you're in Ontario and in Alberta, I'm sure you'll laugh at that. Our version of cold, but still. I'm here to answer all of your employment law questions today and your disability law questions today, long-term disability denials, severance questions, big or small. There is no question too big or too small. Contact us, ask us, get informed. That's why we do these sessions is to let people know out there that there is help. There is resources we make available to you. You can go on our website, employmentlawyer.ca. We have tons of free resources on there. There's there's blogs, there's recorded sessions such as these. There's the employment law show that has been run by Lior Samfiru. There's the disability law show that's been run by Tumarkin for years now. There's saved episodes you can go through. If you have questions about your employment or disability rights, that's a great place to start. There's frequently asked question documents. Or you can just pop on here and feel free to fire away, ask your questions in real time. If you do have a matter, either employment or disability, that is too sensitive and you don't feel like airing it live, that's totally fine. Contact our firm for a free consultation, confidential consultation with any of our lawyers. Go on our website, employmentlawyer.ca. If you want to speak to me directly, my contact details are on there as well. You're more than welcome to reach out to me directly and chat with me. We do operate in Ontario, Alberta, and BC. We help people with employment and disability rights and their claims, across the country. And we have actually our first question coming in here, so I'm going to get to that in just a minute. We may have some downtime between questions today, and so if we do, I'm going to be jumping on some topics such as with the recent layoffs in the tech industry, large scale layoffs. I'm going to talk to people about their rights if you're, confronted with a situation such as that, not just in the tech industry, but in general, and whether or not that impacts any rights you might have for severance. And if you have any general kind of topics you'd like me to cover, and maybe not a specific question, but just to chat about a subject or give you guys some more information, feel free to also write that in the comments. And I'm happy to do that as well. So our first question today comes from Marcus on YouTube. Marcus says, our employer threatened to move our positions overseas because he was unhappy with everyone's performance. Can they just eliminate everyone's jobs like that? So Marcus and everyone else, for the sake of the conversations today, I'll be assuming people are asking questions based out of BC. That's where I practice. That's where I'm licensed. If you have any questions that relate to other jurisdictions, please just let me know. We do have other shows as well. The next show that's coming up will be tomorrow at 1 p.m. Eastern time with Lior Samfiru, the employment lawyer himself. And he's a great resource and will be able to give you the information you need if you're practicing on Ontario and Alberta or BC. And so, Marcus, your question is basically moving people overseas, moving work overseas. Can your employer do that? So your employer, and in BC and in Canada, the employers can terminate you for any number of reasons, as long as it's not a discriminatory reason. So they can't terminate you because of your religion or because of your race. If they want to terminate everyone in a particular office or, let's say, warehouse or manufacturing facility because of productivity issues, they're entitled to do that. And that kind of leads very well into what I wanted to talk to everyone about today and provide some information on, which is group terminations. And that's, so if you've got, I don't know how many people are employed at your place, Marcus, but in the Employment Standards Act, there's a chart which kind of details what group terminations look like. And typically, if you terminate more than 50 people from a single location, the Employment Standards Act triggers enhanced notice requirements. So, for example, you may have to give 9 weeks of written notice of any mass termination that occurs within a 2-week period. And I've actually written a blog about this recently. You can find it on our website. And I believe some of our other associates have written ones specific to Alberta and Ontario as well, which will be on our websites. But generally, if you are in a situation where 50 or more, 50 to 100, or 100 to 300, or 300 or more people are being terminated from a single location at a given time, and in BC, it's within a 2-month period, there are enhanced severance requirements that are triggered, enhanced notice requirements. Um, and these are not dependent on your employment contract. That is, your employment contract can modify your common law severance, so your general enhanced severance, but not your employment standard severance. You are always owed your employment standard severance. And so, Marcus, if you're in a situation where a large group of people, 50 or more is kind of the baseline to start at, it's the threshold, are being terminated, contact us. Have them contact us, because you are owed enhanced notice requirements. Generally, there's nothing preventing an employer from doing that. If an employer wants to take production overseas for any number of reasons, they are allowed to do that, but it doesn't absolve them of the requirement to pay you appropriate severance. And the reason they want to do this is also irrelevant. So whether it's performance based for everyone there, productivity based or whatnot, if they say, listen, it's going to be cheaper, you guys aren't productive enough, it doesn't mean that you aren't owed severance, even if true. Even if you have the most unproductive workers in that say manufacturing plant, if they're terminating them all and moving the operations overseas, they're still owed severance. Those workers are still owed severance. And I would say contact us, and we can give you a better idea of your specific severance obligation or rights in that regard. And so we have another question here off YouTube. It's Brianna. Brianna says, hello, I was recently fired from my job Friday. I was hired end of August and was just under their 90-day probation period. However, I was in the process of getting accommodation to, and Brianna's question seems to be cut off. So Brianna, if you're still there, just maybe add some more details. You might be doing that. Here we go. My accommodation due to disability. I was not ever accommodated despite having my doctor fill out their HR document. I also had a complaint going forward regarding the management's behavior toward me at the office. Can they, and so I'm assuming you're going to ask, can they do this? So, like I've said, your employer can fire you due to any reason. Can they fire me without cause, no severance, and no accommodation? So your employer can generally, again, like I said, fire you for any reason they want, as long as it's not discriminatory. Here, when you're talking about accommodations due to a disability, I'm assuming you have a disability claim. And even if you don't, if you are under a physical, mental disability, something like that, cognitive disability, and they hired you and you gave them medical documentation outlining this disability to them, and requesting accommodations in your employment, and they did not do that, even if they're within the probation period, I would say you definitely have a claim. One of the hallmarks of a probationary period is, and I'll kind of the general of this is within typically 3 months, an employer can terminate you within a probate, which, if that's a probationary period, they can terminate you within that 3 months without Employment Standards Act severance obligations, because those only start in BC after 3 months. Now, part of severance is employment standards severance, which is your minimum entitlements given by provincial legislation, and then there's the common law, which is, if you go on our website, you can go to Severance Calculator, I think severancecalculator.com, and you can even go on our website. There'll be links to our severance calculator that will give you put in your information, that will give you an estimate of what your common law severance is. And common law severance is basically judge-made severance, which is over and above and in addition to your employment standards entitlements. Okay. And unless you have an employment contract, which specifically limits you to your Employment Standards Act severance, so your minimum provincial legislated severance, you would be entitled to common law severance. Part of the hallmarks of a probationary period is the employer can't just use it as a generalized get out of jail free card to say, well, as long as I terminate you within 3 months, I don't have to pay you anything. one of the hallmarks is of a probationary period is they have to give you a fair shot at the job in order to take advantage of that clause. And it's something a lot of employers don't know, and it's something a lot of employees don't know. And so I would say, Brianna, definitely contact us, because if you are in a probationary period and if you were terminated without being given a fair shot to succeed at your job, and in your case, if you were denied accommodations, I mean, you likely have a human rights complaint against the employer for failing to accommodate you. Employers do have obligations to make reasonable accommodations for people with disabilities, especially where there's a medical component that has been filled out at the request of the employer. Um, and if they haven't given you a fair shot to succeed during that probationary period, then they may not be able to take advantage of the protections kind of offered by that probationary clause that I assume is in any contract of employment you sign. So Brianna, I would say get in contact with us, send us a copy of your contract. I'm happy to talk to you. Any number of our associates would be happy to talk to you and give you a better idea of what your rights would be. You can email us. I think it's popped up in the bottom of the screen there at help@employmentlawyer.ca. So reach out to us, Brianna, and we'll definitely give you a hand. Um, and so we have a question through Twitter, and someone on Twitter is asking, does severance change during a recession? And no. So the quick answer is no. Severance does not change. You know, that's the general answer. Is the fact that we're in a recession would not change your severance entitlements. What it may do is it may enhance them. Part of the determination of what common law severance is, or enhanced severance, or what we may call it, is there's a number of factors that go in to determine what your severance should be. One of them is the ability to find replacement work, comparable replacement work. For example, during COVID, this resulted in an uptick in the amount of severance people were generally owed. Where a person might have been owed 6 months of common law severance, now they'd be owed 7 months, because during COVID it was more difficult to find jobs, because a lot of employers were going out of business, very quickly. A lot of people weren't able to hire. There wasn't a lot of revenue coming in for companies. And so those are all factors that are looked at in determining severance. It does not absolve the employer of the requirement to provide you with severance. And so just the simple fact that perhaps the employer is going through, hardship, economic hardship, or there is a recession that's impacted your employer's business, if they do terminate you, they owe you severance. That doesn't operate to protect them. So hopefully that answers your question. Um, and we have another question here from YouTube, and that's Paul. Paul says, "How are benefits usually dealt with after termination?" And so, Paul, depending on the jurisdiction you're in, whether BC, Alberta, or Ontario, the Employment Standards Act, so the provincial legislation that governs employment, may have specific requirements with respect to benefits. Typically, what happens is there's a requirement to continue the benefits through the statutory notice period. And so your minimum notice period under the Employment Standards Act, they continue your benefits for that minimum amount of time, or they may pay you out for that. But typically they continue your benefits for that period. And then your benefits are terminated, typically in accordance with whatever group plan your employer subscribes to. That's with typically extended health and dental benefits. Um, Things like short-term and long-term disability, those typically end right away. Those will end on your quote unquote last day of active employment. That's a function of your benefits contract, the group benefits contract. And so I always tell people this: if you have benefits questions, get a copy of your benefits package, your benefits contract, contact us, have us do a review of it, and we can answer any questions that you might have. And it also will depend on your employment contract. So I should say that as well. Um, And so we have a question through YouTube from PKM Motorsports. PKM says, "I was dismissed without cause in 2021 and provided severance. I got a new job and things were good. Out of the blue, my new employer received an anonymous letter, likely from my previous employer, saying I was terminated due to criminal activity. This was not true. My current I'm assuming employer will likely fire me. What are my options now? So, PKM, I guess that's a very sticky situation that you're in right now. Um, you know, Part of the difficulty here is if there's an anonymous letter without proof that your previous employer sent it, it's potentially quite difficult to go after them for something like defamation. If you can prove the fact that they defamed you with an untrue fact, um, and that resulted in, for example, the loss of your job, then you potentially have an action against them for damages, and for damages flowing from that, defamatory conduct or the lie that they told to your new employer. I think the difficulty that you'll find there is proof. Um, I would probably suggest talking to your current employer and obviously disputing this and providing any proof to your current employer that you can, and perhaps maybe even speaking to your old employer to see if they've gone so far as to do something like that. But yeah, I mean, your new employer, depending on how they terminate you, if they terminate you without cause, which is, I mean, what should probably happen if that's the way that they're going to go, as long as they pay you severance, then there's not really much else to do with your current employer. If your current employer uses this anonymous letter to terminate you, say for cause, which is a way to terminate you for just cause, which is a way to terminate you and not pay you severance, then I would say contact us, because I mean, to me, an anonymous letter without any kind of proof definitely does not rise to the level of just cause, and you would still be owed severance. In my view, I mean, I need more details. Need to look at your contract to determine what your actual entitlements would be, but I think it's definitely worth exploring. And so you can go to employmentlawyer.ca, and you can click on there, put in an inquiry, and contact someone at our office to set up a consultation once you kind of know what is happening with your employer. But I think the first thing to do would be to dispute those allegations against you. And so hopefully that answers your question, PKM. And again, happy to chat offline about more specifics, and details if you have those available. Um, and so we have a question through YouTube from Bonbon. I like the name. All right. So Bonbon says, do unions use a lawyer to get the same legal severance entitlement that non-unions employees would get? How would an employee know if they're getting a reasonable settlement? So in a union setting, if that's what we're talking about here, they don't generally use employment lawyers. They use labor lawyers. There's a grievance process, an internal process to the union. Um, it is very different from the steps that we take. It is very different from a non-union setting, because the rights and entitlements of an employee on termination in a union is dictated by the collective agreements, the collective bargaining agreement for that union. And so you can have 5 different unions that have 5 different agreements that deal with terminations in 5 different ways. There could be 5 different processes set up. There could be entitlements set out in there in a chart, which simply say, based on seniority and whatnot, this is what you would be getting. But unions are their own very specific niche area of law. They're their own beast, and they are typically dealt with in tribunals. If there are disputes with relation to that, the labor arbitrations, and so it is very separate. And that kind of answers our next question from Abdina Nasir Hashi, which is why we don't represent unions. In BC, I mean, I don't represent unions, because I do primarily employee side work. I do represent some employers, but I do primarily employee side work, and I haven't done any union work. It's not something that I practice in. But I believe we do have people in the office who do practice labor side work for employees. I'm not sure about. I don't think in Vancouver, but definitely in Ontario. And so we have another question from YouTube, and it is De Cordova, asks, what happens when your employer makes changes gradually over a long period of time? My employer keeps releasing new policies and requirements. If they had released them all together, I would have objected. So that's a great question. Sorry. And so there's two parts to your question I want to touch on. So the first is actually the last part of your question where you say I would have objected, and that's great. You know, the key is with any kind of changes being made to your employment, if you don't object to them in a reasonable amount of time, you're deemed the law will sometimes look at you as deeming have accepted those changes, especially if you've been operating under them for any length of time. Um, when you're saying that they were released slowly over a period of time, long period of time, a couple questions come to mind, which would be how long, how significant were the changes, were they, were they impacting your job specifically or everyone's jobs? What type of policies are being changed? Did it touch your compensation at all? Was it simply like workplace policies or whatnot? So for here, the devil's really in the details. It does matter kind of what the changes were and how they impacted your employment. If an employer makes small changes over a period of time, and you accept those changes, and they're you've kind of accepted that change as a modification to your contract, a modification to your agreement, and as those changes are released, if they cumulatively come to a point where you look at these changes and you say, well, my employment is so much different than I thought it was going to be, or so much different than it is now. I would say the first thing to do is object in writing. Object in writing to your employer and say, listen, you've been doing these small changes and these were fine, but now you're, say, getting into bigger changes. You're getting into changes that are affecting my compensation, affecting the time that I can come into work or the time that I can leave work, affecting my actual job duties, things like that. And so if you've got big changes like that, I always tell people when you get those changes, let your employer know, listen, I object to these changes. I don't agree with these changes to my employment, and then contact us right away. Because stuff, constructive dismissals are typically what can flow from changes to your employment. If your employer changes enough about your job, it can show an intention to repudiate the employment contract between the employer and the employee, which means it shows that they don't want to be bound by the employment contract with you any longer. If they're taking you from job A, which you were hired in, and essentially transitioning you to job B. Um, so that is a very fact-driven analysis. I always tell people something like that happens, object right away because you've then preserved your right to claim a constructive dismissal with respect to those changes. But object right away. If you want to work under those changes for a few days or a week to see how they really impact you, I think that's generally okay. But what I always tell people is object to those changes. Call us right away. Call us, give us the details. Let's have a chat about what those changes are, how they impact your employment, and we can find a way to you know, set you up either to claim a constructive dismissal or to help you in a dialogue with your employer, to look at the cause for these changes and maybe how modifications can make the changes more agreeable to both parties. That's something we've done as well. So I always tell people, when you have a change like that, if you have any kind of questions or something your employer does just smells funny and you're not sure how to deal with it, call us. That's what we're here for, or hop on here. But for stuff like this, where changes are being made to your job, it is very very a fact driven analysis. So please give us a call, send us your contract, send us the detailing of what your job duties and what the job was before and how it's changed, and let's have a chat. Um, and so we have a question from Rosemary, and so Rosemary's back with another question here, and she says, "My niece has worked for a large brand for the holiday season for the last few years. She was told this weekend they won't be needing her. Is she owed severance?" So Rosemary, if she's just been a seasonal employee, um, it would really I'd really need to know what kind of contracts were signed, but generally when they lay her off at the end of the year, if she accepted that layoff and wasn't paid severance at that time, or if she was understood that she was under a contract for only that period of time, she would have been owed severance at that point. Um, if there's no agreement, a rolling agreement to rehire her, then no, they don't have an obligation to rehire her at this point. Temporary employment, if it's for a specified term, this question really depends on the manner in which she was hired in the previous years. My assumption would be I've talked to some people who were in similar situations, and my assumption would be was that they signed a term contract for, you know, 3 months, and then after that the term would end because they're just seasonal, and that the severance would be paid out in accordance with the term. And if that's the case, then no, she wouldn't be owed severance at this point. If she was getting hired and laid off seasonally, um, and it was only for say less than 2 months a year, then yes, she would be owed severance. If they brought her back, you know, within the after 2 months of being laid off, for example, as long as her layoff never exceeded, you know, 13 weeks out of 20 weeks, so 13 weeks or so straight, then she would be owed. She could be owed severance at this point. But I would say, Rosemary, have your niece contact us. We would need a lot more detail about her position, about her past agreements, and about any agreements she signed in the past or now, to really answer that question fully. I'm sorry I couldn't do a little more with that, but have her contact us. Happy to step in and chat with her. Okay, perfect. Thanks, Rosemary. And so while we wait for, we've got a couple minutes left here, and while we wait for some more questions to roll in, I'm going to just touch a bit on the group terminations and the, you know, the buzz that's been coming around the impending recession, or all the talk about you know, Canada and BC, and well, Canada entering a recession, and just severance entitlements, and I touched on them in an earlier question, and if you missed it, you can always go back and rewatch some of this, but I'll touch on it now as well. You know, if we're in a period of a recession where there's economic hardship on both employees and employers, you know, it is still the responsibility of the employer to pay out severance. You know, just like during COVID, where employers say were not making the revenues that they used to and had to cut staff, economic hardship is not a vehicle for employers to avoid severance, right? There's your severance entitlements to an employee still remain in place. And so if we enter a recession, and you as an employee are laid off from your employer, and they say, listen, you know, you're only owed this much, but or you're owed this much, but I can only pay you this because of, you know, we're not making enough profits. Give us a call, because that is not a reason to not provide you with your legal entitlements. You know, and similarly, when we have people in the tech industry right now, I mean, they're going through a massive period of layoffs. Obviously, you know, this could be recession related, and I know a lot of them, for example, Twitter and Facebook, or Meta, you know, put out releases saying, you know, that they didn't anticipate the economy doing what it's done now, and that they're, you know, laying off a large portion of their workforce, where they're terminating, you know, large amounts of people, 50 or more. For example, if it's in Canada and you're in BC, 50 or more from a single location, there's enhanced severance requirements. You are entitled to enhanced notice of your termination, in addition to your employment standard minimum severance entitlements, and in addition to any common law severance or additional severance you may be owed. So when you're terminated in a group setting, there aren't a replacement of severance entitlements. You're actually owed enhanced severance, so additional severance. All right, and it looks like that's our time today. I hope I got to everyone's questions. I'll be back in 2 weeks. You know, like I said, you can come talk to me in 2 weeks. Happy to chat with you. We have Lior Samfiru, the employment lawyer himself, coming on tomorrow, Wednesday at 1 p.m. Eastern time. You can ask him. He's a venerable wealth of knowledge. So take advantage of these. If you find these helpful, hit like, hit subscribe. You'll be notified when anyone in any of our offices come online. We're always here to help. And feel free to reach out, even offline, www.disabilityrights.ca or help@employmentlawyer.ca. You can give us a call, send us an email. We're here to help. All right. You guys all take care, and have a great week.